Neuro Show, a show all about brain injury and breaking the barriers. And it's that time of year again, the happiest time of the year, the holiday season. And with the holidays comes the opportunity to gather with family, friends, and colleagues at holiday parties. It's a time to let loose, have fun, and socialize, often with open bars. Who doesn't love holiday parties? Today we're going to be talking about just that, holiday parties, open bars, and liability. Who is responsible if an employee drinks and drives and gets into a car accident? And if you're a business or a homeowner, how can you reduce your liability and make sure that your party is as safe as possible? Robert Durante is a partner at Oatley Vigman Personal Injury Lawyers, our show sponsors, and a firm that is consistently ranked as one of the top personal injury firms in Canada by Canadian Lawyer. Their lawyers are frequently recognized by L Expert and Best Lawyers as among the best in their field. Robert is a graduate of McGill University and Queen's University Faculty of Law. He joined Oatley Vigman shortly after his call to bar in 1997. Robert advocates for seriously injured clients and for families who have lost a loved one due to negligence. He focuses on accident benefits, disability claims, and product liability claims. Welcome to the show, Robert.
Thanks, Sarah.
So is drinking and driving a significant problem at holiday parties?
Well, I think it used to be more of a problem years ago than it is now. And I think one of the main reasons for that is an interesting case we had quite a few years ago, and some of your viewers may actually remember the woman who lived in Barrie, and she got very drunk at an office cocktail party. You might remember that case. It received quite a bit of bad press, unfortunately, press for the wrong reasons. But the case was really about the employer's duty to keep his or her employees safe in the workplace, and that legal principle goes back over 100 years. But the press, of course, spun it to be a case about someone who got drunk at an office party and then sued her employer. The facts of that case are very, very specific, and the most important of which is that our client, and her name was Linda, she was working at the time, and the drinking started at 1 in the afternoon, and she was scheduled for work, and she was working. She was the receptionist, she had cleanup duties, she had a number of duties, and throughout the afternoon the drinking went on, and of course it was one of those very casual open bar type scenarios, and by 6 p.m. she was intoxicated, and a group of her and the manager and some friends went across the street to a bar, had a couple of drinks, and then she drove home in a snowstorm. And in that case, the judge did find, under the very specific facts of that case, that the employer did in fact owe a duty of care to the employee because it was the employer that introduced alcohol into the workplace during work hours. And that's the key, and that's one of the facts that really didn't come out in the press. And if, as an employer, if you're going to introduce alcohol into the workplace during working hours, you better make sure you've got a system in place so that your own employees aren't driving home drunk. Now that case went to the Court of Appeal and was overturned for other reasons, but those principles still remain today. And I know when we have our Christmas party or our holiday party, we make sure, first of all, we keep it off-site. That's the first thing you should do as an employer, and try to stay away from those open bar scenarios and hold it at a reception hall or a restaurant, basically places that are in the business of holding parties, and they have the responsibility to make sure people that they don't overserve people and people don't leave their premises and go on and drink and drive.
So who is likely to be held liable then if an employee drinks and then goes on to injure somebody?
Well, the person who's done the drinking and the driving, of course, will be held liable. And going back to that case we had with our client Linda, One of the things, of course, that wasn't reported that should have been was that she was found primarily responsible for her own actions, and the press at the time, of course, didn't report that because they spun it in a different way and made it seem like this woman was suing her employer and the employer was 100% liable. That wasn't the case. The person drinking and driving will always be found primarily responsible for their own actions. And in that case, the judge found Linda 70% responsible for her own actions, which meant she only recovered 30% of her damages. So she was held largely to blame. Now, if an employer, again, introduces alcohol into the workplace during the day when people are working, and the employee then leaves and causes injury to someone else, under the same legal principles, there's a good chance the employer will be found liable.
Okay, and is the same true for homeowners having personal parties?
Good question. With homeowners, different legal principles apply, and that's because, of course, as a homeowner, we're not responsible for employees, and that was the main legal principle in Linda's case, in that the relationship was between an employer and employee, master and servant, and that law has been established for over 100 years. With house parties, there's actually a Supreme Court decision, it's now about 9 years old, where the court was asked to decide that same question. What happens if you have a house party and one of your guests gets drunk, drives away, and then injures someone else? And that's exactly what happened to Zoe Childs, a young woman in Ottawa who suffered a severe spinal cord injury when a drunk driver crashed into her vehicle. That drunk driver left a house party. It was a New Year's Eve party. But one of the very distinguishing facts of that case was that it was a BYOB, one of those, bring your own booze, bring your own beer kind of parties. And under those circumstances, the Supreme Court said, as a homeowner, you can have people over and they can drink. They can then leave and drive. They could be intoxicated. But if you haven't supplied any of the alcohol, then as a homeowner, you won't be responsible. The Supreme Court did leave the door open, though, just a little bit, and said in some circumstances a homeowner may be found liable. The facts have to be just right. But one of those situations could be where the homeowner supplies all of the alcohol and the person drinks to extreme excess and within the homeowner's knowledge, and then goes out and drives when they obviously shouldn't and injures someone. Those kinds of facts have not come before court yet, and I suspect if we came across a case with those facts, the insurer for the homeowner would want to settle that case, because there's a good chance, given the right facts, a homeowner could be found liable for injuries that one of their guests causes while drinking and driving.
Okay, so how can both employers and homeowners ensure that they reduce their liability of having a party?
Right. Well, for employers, and I think this trend has happened ever since Linda's case, that we're seeing fewer and fewer holiday parties or Christmas parties being held on the employer's premises. Most of these parties now are being held off-site, whether it's a reception hall, a banquet hall, a restaurant, and that's great, because then you're putting the duty, you're putting the onus on the establishment, and they're licensed, they're in the business of selling alcohol, and it's their responsibility, no longer the employer's responsibility. So, and that's what we do. The other thing we do is we know, for example, our holiday party, there's alcohol, so we give all of our employees a free taxi chit so that they've got a way to get home, so that there's no excuse and no one needs to drink and drive.
So if employers follow these tips, are they still going to be held liable, potentially?
I would imagine the odds of them being found liable are very, very low, especially if they hold a party off-site, and they create a policy whereby no one is allowed to drink and drive, and they provide people options in terms of getting home, either with designated driver program or free taxi rides.
Okay, so if someone is injured as a result of their own or someone else's drinking and driving, what steps should they take?
Chances are they've suffered a serious injury, in which case they should contact their own insurance company as soon as they can. This, of course, comes either later that day or the day after. The initial steps, of course, are to call the police if it's a serious accident with serious injuries. But people should be calling their own insurance company as soon as they can to let them know.
Okay, and so if someone's injured as a result of an accident and they have a serious injury, how can they contact you?
They can reach me on the internet. Our website is oatleyvigman.com. My name is on there, or they can reach me by email at rdurante@oatleyvigman.com.
Okay. Well, that's also informative, so thank you, Robert, for sharing this with us. In case you missed it, Robert is a partner at Oatley Vigman Personal Injury Lawyers, a top 5 firm in Canada. And we're going to take a quick break and we'll be right back.
Hey, my name is Todd Kierstead, host and founder of Bring Back the Game. What we're going to be doing to you is we're going to be showing you that golf is a sport for anybody, whether you're aged, whether you're disability, whether it's mental or physical, doesn't matter. We're going to get you back onto the golf course. We're going to get you swinging the golf club. We're going to get you having fun. We're going to change your mindset to show you that golf is not about can't, but it's about can, no matter the situation you're in.
Welcome back to the Neuro Show. Thank you, Robert, for joining us today.
Thanks for having me. It was a pleasure.
Okay, if you want to learn more about Oatley Vigman Personal Injury Lawyers, you can visit their website, oatleyvigman.com. And you can follow us on Twitter at The Neuro Show and visit our website, www.neuroconnect.ca. And we look forward to seeing you next time.